It is much quieter tonight outside the Supreme Court. When the sun was up, this area was filled with Super Bowl-like media attention. Inside, the 9 justices asked pointed yet skeptical questions about the effort by 6 Colorado voters to disqualify former President Trump from the ballot. Liberal Justice Ketanji Brown Jackson seemed frustrated with the answers she was hearing. Conservative Justice Samuel Alito reclined nearly horizontal for part of the questioning. Several justices raised the concern that if they allow Colorado to remove Trump from the ballot, what about other states that believe he is still qualified to run for office regardless of the 14th Amendment?
I would expect that a goodly number of states will say, whoever the Democratic candidate is, you're off the ballot, and others, for the Republican candidate, you're off the ballot. And it'll come down to just a handful of states that are going to decide the presidential election. That's a pretty daunting consequence.
Even some of the liberal-minded justices seem to suggest that Congress needs to take action, either disqualifying a candidate or giving the states explicit permission to do so. Trump's name is on Colorado's March 5th primary ballot because they needed to be sent to the printer a month ago. Now we wait for the opinion by the Supreme Court to know for sure if the votes for Trump will count.
There has to be some process for determining those questions. And then the question becomes, does anything in the 14th Amendment say that only Congress can create that process? And Section 5 very clearly is not an exclusive provision. It says Congress shall have power.
But maybe put most boldly, I think that the question that you have to confront is why a single state should decide who gets to be president of the United States. In other words, this question of whether a former president is disqualified for insurrection to be president.
From rising again in the context of these sort of local elections as opposed to focusing on the presidency.
Well, 2 points on that, Justice Jackson. First is that, as I discussed earlier, there isn't the same history of states regulating ballot access at this time. So ballot access rules to restrict presidential candidates wouldn't have existed. They wouldn't have been raised one way or another.
Right, but I'm not making a distinction between ballot access and anything else.
Understood, but the more broad point I want to make is that what is very clear from the history is that the framers were concerned about charismatic rebels who might rise through the ranks up to and including the presidency of the United States.
But then why didn't they put the word president in the very enumerated list in Section 3? The thing that really is troubling to me is I totally understand your argument, but they were listing people that were barred, and president is not there. And so I guess that just makes me worry that maybe they weren't focusing on the president. And, for example, the fact that electors of vice president and president are there suggests that really what they thought was, if we're worried about the charismatic person, we're going to bar insurrectionist electors, and therefore that person is never going to rise.
This came up in the debates in Congress over Section 3, where Reverdy Johnson said, why haven't you included president and vice president in the language? And Senator Morrill responds, we have. Look at the language, any office under the United States.
Yes, but doesn't that at least suggest ambiguity? And this sort of ties into Justice Kavanaugh's point. In other words, we had a person right there at the time saying what I'm saying. The language here doesn't seem to include president. Why is that? And so if there's an ambiguity, why would we construe it to, as Justice Kavanaugh pointed out, against democracy?
Well, Reverdy Johnson came back and agreed with that reading. Any office is clear. The Constitution says about 20 times.
No, I'm not going to that. So let me just say, so your point is that there's no ambiguity. With having a list and not having president in it, with having a history that suggests that they were really focused on local concerns in the South.
He speaks about disqualification from holding office. You say he is disqualified from holding office from the moment it happens.
Correct, but nevertheless...
So it operates, you say that there's no legislation necessary. I thought that was the whole theory of your case. And no procedure necessary. It happens automatically.
Well, certainly you need a procedure in order to have any remedy to enforce the disqualification, which is different.
That's a whole separate question. That's the de facto doctrine. It doesn't work here. Okay, put that aside. He's disqualified from the moment. Self-executing. Done. And I would think that a person who would receive a direction from that person, the president, former president, in your view, would be free to act as he or she wishes without regard to that individual?
I don't think so, because I think, again, the de facto officer doctrine would nevertheless come into play to say this is
no de facto. That doesn't work, Mr. Murray, because de facto officer is to ratify the conduct that's done afterwards and insulate it from judicial review. Put that aside. I'm not going to say it again. Put it aside. Okay. I think Justice Alito's asking a very different question, a more pointed one, and more difficult one for you. I understand, but I think it deserves an answer. On your theory, would anything compel a lower official to obey an order from, in your view, the former president?
I'm imagining a situation where, for example, a former president was, a president was elected and they were 25 and they were ineligible to hold office, but nevertheless they were put into that office.
No, we're talking about Section 3. Please don't change the hypothetical, okay? Please don't change the hypothetical. I know I like doing it too, but please don't do it. Okay?
Well, the point I'm trying to make is
he's disqualified from the moment he committed an insurrection, whoever it is, whichever party, that happens. Boom. It happened. What would compel, and I'm not going to say it again, so just try and answer the question. If you don't have an answer, fair enough, we'll move on. What would compel a lower official to obey an order from that individual?
Because ultimately we have statutes and rules
that this court has held. You're not contesting this or asking us to revisit that decision in Thornton or term limits or whatever you want to call it, that it has to come from some federal constitutional authority.
No, we are not, Your Honor.
Okay. And here we're not talking about the qualifications clause, right? Nobody's talking about whether he's 35 years old or natural born, whatever, right? Not at issue, okay? We're talking about something under the 14th Amendment and Section 3. So that's where you have to find your authority, right?
We find our authority in Article 2, in states' plenary power to run their elections.
Federal election, but this is for a federal office. It has to come from the Constitution, and you're seeking to enforce Section 3.
We're suggesting that in their broad power to determine them, to select presidential electors in any manner they see fit, they can take account of Section 3 and apply Section 3.
Could they do it without Section 3? Could they disqualify somebody for, on whatever basis they wanted outside of the qualifications clause?
That would run into term limits,
I would think so, right? So it has to come back to Section 3. And if that's true, how does that work, given that Section 3 speaks about holding office, not who may run for office? It was a point Mr. Mitchell was making earlier, and I just wanted to give you a chance to respond to it, because it seems to me that you're asking to enforce in an election context a provision of the Constitution that speaks to holding office. So it's different than the qualifications clause, which is all about who can run and then serve. Yeah.
I don't know that it is different. Okay. Other qualifications for office similarly talk about eligibility for the office. There's nothing unconstitutional about a 30-year-old trying to get on the ballot.
Except for this disability can be removed, right, under Section 3. That's what's different about it.
Kujichagulia.